Maria Luisa Stasi, Mark Dempsey, welcome to the DMA Lab, our joint project with Konstantina Bana, where we aim to invite experts in the DMA and maybe occasionally in the MCCA to discuss the nitty-gritty of this new regime. And our today's conversation will be about, first of all, your remarkable conference, which you run already for 3 years in a row, creating a fantastic atmosphere in the event itself, the vibe of curiosity and kind of genuine interest in the DMA and surrounding topic is really there, and it's a great skill to do it. But Konstantina and I want to discuss with you broader set of issues related not only to the event itself, but also about the DMA regime. You see it from the inside in many respects. You know things which we don't. And so we hope to have a fruitful, amicable, collegial exchange of opinions without making any commitments, so to say. Let me pass the floor to Konstantina to ask the first question, perhaps.
Of course, and please allow me to thank the speakers today. Many thanks for taking the time to talk to us. So I will just start with a very basic question, which is whether one of you can tell us what Article 19 is about. What is the organization about? What are the main causes that you seek to promote? Before we move on to the more DMA aspects of our discussion.
I think I'm going to take that. So what we've done is we've split this between us, and this is where my caveat comes in. I'm not a lawyer. So going into the nitty-gritty is definitely left
we won't blame you
for
for
Isa. So my job here is to lead on EU advocacy related to the Digital Markets Act and those other regulations which have implications for freedom of expression and access to information. And I just want to thank you both for inviting civil society, because it's not very often that civil society is included in these discussions. So we feel both honored and flattered to be involved in this format, which has become extremely popular, and it's quoted all the time in Brussels circles. You'll be happy to hear. So Article 19, it's a global civil society organization that works for a world where all people everywhere can freely express themselves and actively engage in public life without fear of discrimination. To protect freedom of expression online, we advocate for pro-competitive solutions to dilute corporate power and guarantee diversity, openness, and fairness. So those last three words will speak very much about the DSA, the DMA, competition law in general, and the European Media Freedom Act. So within the Brussels bubble, so to speak, we also operate as part of an anti-monopoly coalition. And over the last number of years, I think really Isa sort of led the charge to build capacity on the civil society front to be able to at least contribute to the competition debate and competition policy and law. Because prior to that, it was very much, I would say, more for the sort of elite law firms and the big tech and those firms representing big tech who are feeding into the discussion, which of course means that a whole sector of society is inevitably left out of the discussion. So there was a gap there for civil society to properly start responding to consultations, to liaise with commission officials at the various events, and to represent ourselves on the different panels when discussing competition law and the Digital Markets Act in particular. And then when it comes to what our actual aims are, I think during the legislative process, which predates my time with Article 19, it was Isa and a number of other people who advocated for a Digital Markets Act that ultimately improves the way markets work, with users' rights central, with the goals of creating a fair, open, and free digital environment, and that this can only be achieved if service providers respect certain quality and human rights standards, and markets are no longer controlled by a handful of gatekeepers. I think our main emphasis is on, one, the fair, open, diverse markets as a precondition for fundamental rights to be respected online. Two, that interoperability and access obligations, but also time, bundling, and self-preferencing, as put by Isa before, all choice eroding or choice eliminating. And then our two main objectives are open markets to plurality and diversity of players and of business models, and to give choice back to users. I think overall, broadly speaking, the DMA is seen as an opportunity to re-engineer the market and to achieve public interest goals. And we saw this as an opportunity that particularly Article 19 in our own mission couldn't afford to miss. I don't know, Isa, if you have anything further to add.
Come on, how can I add something on this? It looks ambitious. No, what I would like to add is that yes, a thank you to both of you for this invitation, and indeed just to note the fact that we've gone a long way, I think, as civil society. About 5 years ago or so, we wouldn't be able to sort of have this conversation. And now I can proudly, in a way, say that many of us, many civil society organizations, we are part of the debate in a way or another. We're developing strong takes. We engage with regulators and different kind of actors. So I see us consistent, still slow, but very consistent change. And I think that, in this timing, considering how 2026 started, to sort of kick off with positive messages, it might be a new trend. So let's hope.
Isa, can I ask a follow-up question? Because you mentioned we engage with regulators. So other NGOs, civil society organizations that may be building things from the ground up, just like you do, but are at earlier stages. Can you tell us a little bit what you have been doing? Have you been replying to public policy consultations? Have you been requesting meetings with the commission? What have been the main areas of activities in which you engage?
Sure. So ideally, and if resources and time was not the constraint that it is, I speak for Article 19, but I think I can speak for the majority of the civil society organizations, especially, after last year, we've gone through a very difficult time. But we try to be present at different layers. So some of us, we have also the legal and technical expertise inside, or we have a network of people where we can sort of rely on to gather that. And we go a little bit beyond the advocacy, the more traditional advocacy engagement. So the idea is to try to contribute to the discussion and to the narrative, because we do have, and maybe we can elaborate a little bit further later on this, we do have, I think, a problem with what kind of narrative is presented out there about the DMA, about the gatekeepers in themselves, the role that they have on the economy, on society. And I think to a certain extent it's fair to say that this narrative has been captured and probably is captured. And so to sort of present different voices and different ideas and different perspectives is essential and is a challenge, because by no means our resources and our visibility can be comparable to the visibility of gatekeepers. So this is the first struggle. The second one is to try to sort of now we have the DMA, the DSA, the AI Act. We've been engaged in the negotiations as we have managed in the past. Now is about enforcement. So enforcement is not necessarily a comfort zone for civil society. You need to have a lot of specific expertise. It's not undoable, and in fact, as I said before, I'm proud to say that a few civil society organizations, they're getting equipped to do this. But also enforcement of the DMA is particularly difficult, because you not only need to sort of be able to reason in terms of some legal arguments that have element of novelty, because the DMA, yes, is sort of built on top of traditional competition law and policy, but it also adds a lot of novelties, and it's still a work in process. A work in progress on that front. There are a number of benchmarks that need to be developed, a number of criterias, and it will only happen with consistent enforcement, possibly also a lot of case law around it. But the point is, monitoring is also extremely complex. The DMA implies a number of obligations. We have these major players that they need to respect them, and more often than not, 80%, 90% of the compliance is a technical issue. So the point is how you can see this. Are they complying or they're not complying? Are they complying, in full or only partially? Is this going to be enough? What is changing in the market and what is not changing? Where are where are the problems? Where are still the problems? So this is a massive effort. The European Commission is trying to do what they can, but they need help. So the point is where this help can come from. From other market actors? Yes. But if we're thinking about the public interest and realizing the objective of the DMA in the public interest, maybe this goes a little bit beyond business-to-business relationships. Maybe we need to bring in the end users. Maybe we need to bring in other considerations. So even the monitoring and the flagging and the sort of trying to figure out if this is working or not, Ideally, civil society has a big role to play. We're trying. As I said, we've managed a couple of times to raise a point with the European Commission. We've sent, our own ideas with evidence and a legal argument, or, more than one legal argument saying we don't think this specific gatekeeper is complying with this specific obligation, and those are the reasons. We've done that in Britain. We've done that in conversations. It's hard, but it's a start, I would say.
And I think that this is a topic we can come back to later, but it's really important to also recognize that a lot of the information that we would actually need to go to the Commission and make an argument is not there. Because one of the main criticisms against the compliance report is that they don't have sufficient detail for business users and civil societies to be able to understand compliance, right? So there's still this information asymmetry.
Yeah, I think just to add, I think there's a huge information asymmetry. I think when you talk with other, for example, search engines like DuckDuckGo, I think when you have them working with us when it comes to information sharing and letting us understand what their issues are when it comes to, for example, the issue of choice screens, I think they've been a useful partner when we're feeding back to the Commission. And I certainly think that we've built up decent relationships with the Commission where we're exchanging information on a daily basis based on what we hear in the likes of MLEX and whatnot. And then there was the occasion of civil society being invited to the high-level expert group. And I think that was a first. And when you have the European Competition Network, you've got the various DPAs, you've got the Commission present, it was an opportunity to voice our concerns vis-a-vis how we can be involved more in the information process and have more transparency to the compliance decisions and how they're made. I think it'll be discussed later, but in terms of civil society involvement in the enforcement process, I think that's going to be a more challenging part for us to be part of.
It's key. And I just wanted to make one remark because I fully agree with Lisa regarding the point she made on the DMA and bringing in the end user's perspective. I mean, obviously the DMA is primarily about B2B relations, but we should not be forgetting about the fact that the obligations will have and already have a direct impact on end users. A lot of the obligations concern online choice architecture, consent, and all these sorts of issues that, of course, affect end users on a day-to-day basis. But let me just pause there on the more DMA-specific issues and pass the floor to Oles, who wanted to ask a couple of questions regarding the civil society perspective and lobbying more generally.
Thank you very much, Konstantina. Indeed, and you have picked on so many interesting aspects which I wanted to elaborate. The first one is that you have mentioned that the Commission needs help and they need information from reliable sources. And it's important to build reputation, and it's important to demonstrate how civil society, how each specific NGO is trustworthy. We are mindful of the plethora, if not hodgepodge or cacophony of different interests, trying to somehow to find the channels to the ears of the DMA team, and for right reasons and for maybe toxic reasons, or for combination of both. So my question is, do you, how big this civil society is, how many organizations, I don't want numbers, but you're feeling how busy, how crowded the space is, how confident you are distinguishing between genuine civil society organizations and purely astroturf fake? Or there are different shades of it, and there are some which occasionally engage into this. So can you just give us a flavor of this very, very interesting and very underexplored routine of the DMA surrounding bubble, perhaps?
This is a great point and is extremely sensitive, I would say. Probably we need to, try to call things with their name. I do believe that what you're saying is essential because we do have an epistemic problem. So we need to sort of, if we zoom out, we need to see at the European Commission in the context, and we need to ask ourselves the question, why they know what they know? Where are their sources? Exactly as you put it. Who are the people that are whispering in their ears? What kind of reports they read? What kind of evidence they have access to? And so on and so forth. there are procedural things that they can rely on, the European Commission team can rely on to get further information or further evidence or to test them with competitors and so on and so forth. But the point is, generally, why they know what they know. We know you use the term like it can be toxic or it's a very busy environment. It's very polluted, if you ask me. There is a lot of material which is produced that has little to zero merit. That is not based on real evidence, that is just assumptions, that is just specific perspectives that are presented as a truth, but they're not the truth. They're just an agenda. And this is time consuming. It's destructive and it's time consuming. And we've noticed this when we first organized our DMA Symposium, that we tried to close the doors to anybody that was not a sort of an independent academic or had something to say and could disclose their sources, etc. We didn't want lobbyists in the room. And the European Commission really appreciated that. They came back to us and said, well, this is a very good space for discussion. We actually learned something. So I do believe that there is an overpopulated environment, so to speak, where the majority of the material and the reports and the narrative that are out there, they're lacking sound roots. Now, to unpack this is a full-time job. And to be also able to fill the massive gap that is left if you just take all this material out of the desk is also another full-time job. Some civil society, they're trying their best. As you rightly said, on top of it, we sometimes compete for the space and the little attention that we can get with other sort of initiatives that in a way or in another are piloted. Now, I am once again also optimistic, although I pictured, I'm aware, a very negative scenario. In a way, it's becoming easier and easier to realize what we're reading and where it comes from. So I see, again, slowly but consistently, an awareness raising of the importance of, before reading whatever, sort of trying to say, okay, what is the source? Where does this come from? Who has written this? Is there a disclosure? So we're getting slightly more sophisticated on that. 5 years ago, you wouldn't go to a discussion or even an event discussing competition policy or competition law and asking each and every speaker, can you disclose if you have any conflict of interest? Can you, or having those disclaimers at the beginning of each and every paper? It's not happening every time, but it is happening, and it didn't. So this is also a very, very important step. Is this enough? We'll still have this massive imbalance of resources, but I'm hoping that because of this system of more transparency, so to speak, then everybody can be more selective in dedicating the little attention they have at disposal.
Maybe just to add to what Luisa said, I mean, there's definitely a consciousness of the problem of astroturfing and whatnot, because it is so endemic. And I think it's more often than not that people are beginning to disclose. I mean, I think when I think of a concrete example, I think of the DMA compliance workshops, which were very interesting in the different strategies that different associations and stakeholders took. But it was, at least to civil society, very clear about who represented whom. And towards the final workshops, there was much more emphasis on disclosing because we raised it several times within the workshop. So I think it's part of civil society's job as a sort of monitoring compliance and checking, because I think the commissioner, it's not perhaps a priority for the commission, but they're certainly more aware of it, given that we've raised it so many times.
And it's also part of addressing that information asymmetry, right, that we discussed earlier.
Yeah, absolutely.
A quick follow-up, and then we revert. I'll pass the floor back to Konstantina. I wanted, obviously, the DMA is designed at one of the versions of the DMA. I remember there was a article on third parties with legitimate interests or something of this kind, and the Commission was very keen to avoid this new kind of stakeholder being formalized for the reasons I presume that they know that there are so many potential combination of factors which can be communicated to the commission that all things we will be doing is just responding and scrutinizing this avalanche of information. So I imagine from this, if this observation is right, that they want to be selective. But for this is a genuine question. Do you think they are focused on the kind of case by case, non-compliance by non-compliance, or they have a broader picture in mind and broader strategy in mind, using non-compliance investigations as a means to build up this? So is it kind of top-down approach or a bottom-up approach, or the mixture of both?
I would definitely go for the mixture of both. And I don't think, because I think those are two possible like medium long-term goals that are not alternative. If we want to have a proper and more sort of a democratic enforcement of the DMA, by democratic, I mean participatory, so that the different stakeholders can sort of chip in with their 2 cents or more, ideally. We need both. I think there is a major issue there. So Costantina hinted at that before, and then we left it for further discussion, but let me bring it back right now, which is the asymmetry of information, how much information is available, and how easy or extremely complex can be to sort of bring more information in terms of evidence or in terms of reasoning and so on and so forth. There is also another major problem, which is administrability. So if you need to hear more people, or if you need to involve more people, more stakeholders in the process, obviously, this is time consuming. So I think we need to think in terms of striking a balance in between ideally having everybody consulted at every step of the way, and the fact that we're never going to get there if we need to do this. I don't see it as a black or white. I think there are many possibilities in the middle, and probably is a learning curve. Probably the European Commission should sort of try to test different possible ways, maybe with the help of also national authorities, and see, what the best practices could be out there. And then in a couple of years' time, we might have some procedural best practices that are aimed specifically at making all the process more participative, that prove to work better than others. This can take various forms. For example, we can sort of push for having more information available for the general public, for the end users we were mentioning before, for the civil society, even for business players, because the compliant reports that we have, it's hard to consider that they are enough. When there are investigations, there is very little available for the non-involved parties. It's when the European Commission is thinking about a decision, there is sort of no possibility to really know anything in advance and provide comments or suggestions, not even at the level of the high-level expert group. For example, we're seeing this with a pay or consent decision. That someone would imagine that, for example, the European Commission could get proper feedback from data protection authorities or data protection experts or civil society, working in the field. But this is not happening. What we're going to do, we're going to comment on what is already out there when it's going to be finalized. So there are ways. The administrability issue is a serious one. So as we try not to undermine it. Maybe there is a lot to learn from the competition environment.
But Isa, this is exactly what I was about to ask. So you mentioned, of course, administrability is a big issue, and I fully agree with that. But for example, in competition law, we have market testing of commitments, right? And there is a limited time frame within which affected stakeholders can provide their views on the commitments that were proposed by the undertaking under investigation. Couldn't we follow a similar approach when it comes to
it could be
the DMA issues?
I think what we need is a specific exercise at 2 levels. So the first one is we need to sort of reinterpret or question, at least question, have a proper discussion about the meaning and the boundaries of a specific concept like affected parties or legitimate interest. Because the way it has been interpreted in the past in a competition environment, it has been mostly a B2B relationship. And now we sort of need to consider that if the goals of a regulatory framework are fairness and contestability and choice, this probably doesn't end at the B2B relationship. And I don't think I need to convince anybody. I mean, we can discuss this forever, but I'm absolutely convinced that the DMA is not just a B2B, and there are, many proof of that. So working on those legal concepts will be helpful. And to a certain extent, I think this can be done not only by the European Commission, but also by courts, because if some civil society or some end users representative, they try to test in court the meaning of this concept, maybe, there will be the possibility to obtain a favorable interpretation and then to start applying this. So this is one. The second one is the market test and so on and so forth. I do believe that possibly also at the level of regulators, we need more participation. I mean, we've mentioned already the high-level expert group, but the DMA in itself, the wording of the DMA limits the exchange of opinions and advices on general topics. I'm rephrasing, of course, but the point is it excludes the possibility to discuss the details of a specific case. I can see the point, or I think I can see the point. There is the need to harmonize the application. There is a need to have some part of most of the enforcement of this regulatory framework centralized to avoid drifting in different directions. And this is a single market issue. But on the other side, we need to sort of consider that a really, truly holistic assessment cannot be better off if it comes out of the contribution of a number of different experts, right? Not just one team. So I do believe that there could be a way to sort of have way more discussion, inter-regulatory discussions about the different cases without necessarily losing control of the situation. Again, a balance to be, identified. What I do understand all this, and I also understand that it might take time. What I can't really accept, or is hard for me to accept, is radical positions where I say, no, this is not going to happen, it cannot happen, it's not going to be administrable, is going to necessarily lead to conflict and fragmentation. I think there is always a way, and we've come a long way, so it would be very dismissive and superficial to just give up upfront.
And if I may make one quick remark here, I don't see how this would lead to more fragmentation. I would say that this would lead to more consistency and harmonized decision-making to avoid conflicting outcomes. For example, it would be a very difficult position for the Commission to have the ETBB say something completely different than what it said in its meta case, right? So if we have a more formal regulatory cooperation framework within the DMA, but also within other instruments, I can see that the duty of sincere cooperation will be complied with. I can see more consistent interpretation of the rules, and therefore I see more effective enforcement in the long run.
Can I just add a comment to what you just said, Constantina? I mean, at the high-level group, I was taken aback at the lack of sincere engagement, for want of a better word, from the different DPAs and the different competition authorities. There was virtually none. It felt like a very informal, unstructured setting. But just an idea, on the DSA side, for example, you have ARCOM, and they've got a special civil society liaison officer who they interact with on a regular basis. I don't know if something similar could be set up for the DMA at a member state level, but to ensure that this constant flow and sharing of information, it could be useful. How it would work, I don't know.
Of course, and it wouldn't replace consumer protection authorities, right, that are represented within the high-level group. No. The civil society would do something different and complementary to what consumer protection authorities arguably do.
Yeah, I think at the moment we're still sort of showing that we can add value. But at the same time, I felt that at the moment there doesn't seem to be consideration of formalizing an exchange with civil society in the enforcement process, based on what Lisa's just said.
I think eventually we will get there, hopefully sooner than later. I mean, we see in many other parts of the world, like Australia, Ireland, the UK, we have these regulatory cooperation forums, but in most cases, these are informal forums. So hopefully we will get there.
And I think on this one, sorry, two additional cents. I think it's worth mentioning that this is happening at national level, but also regional and possibly international level. The Council of Europe, for example, one of the expert groups that they're going to have starting from this year and for the next couple of years is supposed to explore the role of media regulators, but also other regulators vis-a-vis digital platforms. So the idea is also to try to go deeper and issue some guidelines around what kind of possible cooperation and coordination the different regulators should have to sort of be up to the challenge. And also, UNESCO is in the digital governance discussions. They have a layer of discussions among the regulators, the different regulators that include data protection, media, consumer protection. So this is happening. We need to be very concrete here. So we're coming from a long, decades-long tradition of one policy goal, one tool, and never overstepping outside of the mandate, because this would create legal uncertainty, lack of legitimacy. So there are a number of legal issues that need to be, we need to be careful assessing and addressing. But obviously, those decades ago, when this started, markets were not that converged. And services that we could buy on a market, services or products, they would never impact at the same time our economic life, our social life, our political life. So if those things have converged, it seems obvious that then the relevant regulators, they also need to find a much better way to converge.
100%. Fragmentation is not a sustainable strategy in digital markets.
One final comment on this, Konstantina, sorry to interrupt. I think a challenge is, how do you get national competition authorities to really engage in the DMA? I think that's going to be an issue. I mean, I think Germany, I don't think it's an issue, but I think certainly in the case of Ireland, I think they've just basically left it to the Commission, which as the main regulatory body is fine, or enforcing it. But if there's going to be proper information sharing and the high-level expert group is taking this serious as it needs to be, they have to be sharing information better or coordinating better.
Of course. I mean, I think this is what the duty of sincere cooperation is about too, right? And the Meta Platforms judgment is trying to provide some instructions to competition authorities and other regulators in terms of how they can actually work with one another to avoid conflicting outcomes. So yes, there's lots to be said about regulatory cooperation. I was about to ask whether this is an issue of resources, but I think you covered me saying that, it can also be an issue of conflict of interest to some extent, competences, and many different factors that will definitely affect the everyday work of a competition authority or other regulator.
Exactly, and maybe not even not necessarily interest, not only interest, but also perspectives. You can be really well motivated, but see everything through your professional prism and giving priorities to other things. I wanted maybe to continue this conversation through the prism of your conference, because it's really it's a really very healthy and very kind of cognitive wise, very generous and informative gathering, traditionally happening every, I think, November or late October. And maybe you can reflect upon the main topics, the main messages which the selected contributors have shaped during this two-day event in November 25, and perhaps maybe also reflect upon the plans for the next symposium. Isa, let's start with you.
So I'll tell you two things. The first one is it's difficult to sort of look, each year is a different thing. Now, the perception this year was that we finally have a lot of material to discuss. So we were able, because the enforcement has kicked off properly. Last year already did, but it was like the very beginning. So this year we had quite a few decisions to discuss on, and so on and so forth. What I think it was very good was that we had the possibility to zoom in on very technical, specific issues, but also to look at a big picture and have a comparative perspective, which was extremely enlightening. We had discussions about how things are evolving in comparison in Brazil, in Japan. And it was, what we were comparing were mechanisms that are already sort of moving. It was not just the theory, it was also the practice, and it was super interesting. For the rest, I'll let Mark discuss about what the main topics were. I'll tell you what we didn't discuss enough, or at least what I think many of the people in the room, they perceived would deserve way more discussion and way more action. It wouldn't surprise you that one of the things was the narrative. So most, if not all the stakeholders therein, including the regulators, the European Commission, they do perceive that the narrative out there about the DMA is far from reality. And this is not given sort of enough merit to what the DMA could potentially achieve, is trying to achieve, and the way it is working. It's way too often dismissed. It's way too often attacked, also for geopolitical reasons. We all know this. I don't need to elaborate on this right now. But yeah, the shared perception is that it's not fair. Another thing we didn't discuss enough, I think, is that we're in a bubble. So the four of us, we know what we're talking about, and probably many other people, but there's still plenty of market actors or public interest technologies that they actually, or end users, not to say, they have little or no idea whatsoever of the rights that they have based on the DMA, and even less so, how to sort of activate those rights if the market doesn't deliver them itself. Those are two major problems, and I do believe they're very linked with the narrative issue. The third is cloud and AI. We were lucky enough to have by pure coincidence, of course, the event in the second half of November. So very close to the European Commission informing everybody that they were opening investigations. What can I say? Let's see what we are able to discuss next year on this. There were a lot of proposals. There were a lot of hints that this is crucial, is going to be crucial, is already crucial, but not much to discuss. So my hope is that next November we can discuss this in way more details.
Yeah, I think that it was also helpful that the DMA review came around more or less at the same time. It was, I think, DMA review just preceded, so we had our submission at hand. The actual event itself, just to give it some context, so it was the third iteration, and as Isa said, this was much more substantive because there were things to actually discuss. There were ongoing cases and non-compliance examples and whatnot. This one was called Digital Markets Act Enforcement, Impact and Next Steps. And it follows a sort of rigorous process of it. There's an independent scientific committee, there's a call for papers. And it's nice to be able to say that the supply of submissions is usually quite high. So there's quite a process of picking appropriate papers for the event. It lasts over 2 days. It's a closed session. And there's a mix of regulators, academics, people from the commission who are matched with the papers according to their expertise from the DMA enforcement team. And I think this adds a lot to the discussion. And then independent of that, there's a so-called a board or a bench of independent technologists. So they have been watching firsthand what is and isn't working from a technical perspective. And they're given free rein to intervene where they see fit in the discussions on the various papers. And I think both we and the Commission have really appreciated that sort of novel addition, if you want to call it that. Just to give some concrete examples of what the actual clustering was and how it worked. So the first cluster, as we call it, was on the DMA and AI, which included papers on the DMA, whether it was fit for purpose when it came to gatekeepers' use of AI and how AI agents might be brought in under the DMA. The second theme we looked at was the DMA and its influence beyond the EU. So there was a paper, for example, which considered similar legislative efforts in India, and one which compared a similar law in Japan's Smartphone Act, and another one which looked at the implications for the DMA on mobile ecosystems in Brazil. The third panel or cluster looked at private and public enforcement with papers and collective redress. under the DMA and what the possibilities are, and were more process oriented. So there was one from Giorgio Monti and Alex Destriel, which delved into the DMA implementation process so far, using data from interviews carried out with a range of DMA stakeholders, which was actually very instructive. I'm just going to quote from one of the conclusions, which I think would be helpful. So looking forward, the DMA enforcement requires a recalibrated balance between flexibility and predictability. Informal dialogue must be supported by greater transparency, clearer guidance on objectives, and structured multilateral engagement to avoid reliance on bilateral negotiations alone. At the same time, the Commission should be willing to escalate to formal instruments where necessary, coupled with transparent prioritization criteria and more standardized compliance reporting. The fourth panel brought together papers which delved into the nitty-gritty detail, looking at, for example, the efficacy of specific provisions such as 6.3 and interface design, interoperability under 6.7, and in this instance, a study of Google's non-compliance with the Android open source project since its release of its Android 16th operating system. Finally, the final panel was called Nature and Boundaries and included papers which questioned the ongoing existence of the so-called Brussels effect in the current environment. And there was a bit of geopolitics which naturally came into that. And I think Isa can probably refer a little bit to this, but we had a fireside chat with the former Deputy Director of the FTC's Bureau of Competition, John Newman, who is now at the University of Memphis. And he gave a very interesting discussion on his experience when he was at the FTC and some of his more broader considerations on the DMA and wider competition law, which Isa may or may not be able to address, dependent on your memory of the time.
A wealth of topics. I mean, where do we begin now? Shall
we covered a lot
from the broader picture? Because you mentioned that the conference took place very close to the DMA review process consultation, right? So in your view, based on what you heard at the conference, but also based on your day-to-day work, what do you think are the main points that need to be addressed by the Commission as it works on the DMA review?
So I think
maybe also if you have managed to process the submissions, because I think they've been presented not in the most digestible fashion.
Yeah, I even had trouble to sort of download all of them in the formats. So I think it was there was a lot of consensus during those 2 days, but and also it comes from the summary of the submissions that the Commission published recently. That there is this idea that the DMA needs to be actioned in the cloud environment. I think there is no consensus on what the priorities will be there, and also what kind of approach needs to be taken. And also, and then the other point for the AI is, I think it's fair to say that everybody's wondering how fit the existing rules are for the AI system and services. And there are two major exercises to be done here. And maybe people, they can be more on one side of the spectrum or the other side of the spectrum, which is, let's work with what we have and try to find a way to sort of stretch the interpretations a little bit. Or this is absolutely not enough. We need something more, and as soon as we get it, the better. The sooner the better. I think for the first, probably a very interesting legal topic, and I'm sorry, Mark, to bring this in again, is the issue of integration of services. Because the definition of what a service is and whether it falls within the scope of the DMA or not, when it comes to AI functions, words matter, as we know. So this is going to be a critical issue. The criteria that we will need to use to select whether we're talking about a different service or a function of an existing service and what kind of integration will lead to one or the other is something that will keep us engaged for a while, is already keeping us engaged, and is keeping us engaged, not surprisingly, probably for that issue of convergence that we spoke about before. Is keeping us very engaged when it comes to DSA, for example. Think about Grok and X. There's been a lot of reporting and a lot of talking, and if you look carefully for the wording that has been used there, it seems to be pretty interchangeable. It seems to be like it's a function, it's a service, it's an additional service, it's something integrated, it's something added, it's something that is part of the package. It might be way less relevant for the DSA purposes. But the way we're going to define this under the DSA, one could think that it's important to sort of do it right already, because then we can just use the same interpretation for another regulatory framework, because we're looking at the same service, at the same thing. So I do believe that there is going to be this additional layer of complexity, which is however we want to move under the DMA, then it needs to be a workable solution also for the application of the DSA, for the application of the AI Act. And if not, if we want to have departing definitions and departing interpretations, then we need to have solid, objective reasons for doing this. Or legal certainty is going to be just a dream.
Can I make a couple of remarks on this point? Because you mentioned cloud and AI, and I fully agree with all the points you raised. So when it comes to cloud, the DMA is not very clear as to whether it covers all of the different types of cloud services, infrastructure as a service, platform as a service, software as a service. Are all these three covered? And obviously, this is very relevant to the development of the AI marketplace. Then we have the other discussion, for example, whether generative AI qualifies as a core platform service in its own right. But also the very interesting point you raised about the integration. And I fully agree with you, words matter. And I think that we're moving away from, an economics-based discussion that we used to have in the context of competition law and competition economics. And we move to a more technical discussion. For example, AI overviews, is it a separate service or part of Google search? And what does this mean for DMA enforcement? For example, if AI overviews is a separate service, then Article 6.5 on self-preferencing kicks in. And if not, then it doesn't. So there will be a lot of creative thinking that regulators have to do to make sure that they are able to use a tool that does not necessarily need to be revised to address some of the issues that they currently face. And the same applies to the DSA. If, for example, it's part of an integrated service, then it may qualify as a VLOC or a VLOCI, to the effect that all of these obligations kick in, for example, with respect to Grok, right? So there will be a lot of creative lawyering to be made, I think.
Exactly.
Sorry.
Go ahead.
I was saying, I totally agree. And I think that what we call creative thinking is also a lot of experimentalism. And I don't think we need to be afraid of doing this. And I do also believe that in order to guarantee legal certainty, courts are going to be necessarily very, very useful in this. I think we need to be able to sort of calibrate our expectations and say, we're not going to come up with all of this in a month. It's going to take time. But it's a good thing that it's going to take time, because then we can test it on the way, and it's better to get to solid, very, very solid tools to work with in a year time than to get with very weak tools in a month, and then we need to start from scratch again. First point. Second point, cloud. Does it cover it all? It doesn't. Once again, we can approach a number of perspective or a number of positions. The two, I'm trying to simplify once more, is literal interpretation, or we're going to go for a goal-oriented interpretation. So let's look at cloud as a production environment, as a sector, and let's look at where fairness and contestability are not there, because this is what the DMA is for. So that should be the driver. Similarly, the integration, as I said, is going to be a very, very good legal discussion. I do believe that one of the possible way to approach it could be to sort of try to think about the pros and cons of having the different interpretations. And I think it's essential to measure the pros and cons, or to better say, to focus on the trade-off of this possible qualification based on and assess them against not only the B2B relationships, but crucially also the B2C relationships, because otherwise we're sort of we're going to fix in stones, or so to speak, crucial interpretation for the enforcement of a regulatory framework, but we're not going to be able to include properly end users' rights if we don't take them into account when we fix these definitions. So in the trade-off, this perspectives and this kind of the impact on end users' rights needs to be brought in.
Of course, and that's easier said than done. Can I make one quick remark? And I think that Oles will also have something to say, because Isa, you made a point on judicial review, and I'm still waiting to see how far the court is willing to go, because obviously the case law in this area, I mean, when I say case law, I refer to the judgments of the Court of Justice, the General Court, is emerging. And I'm really curious to see whether the court will give a lot of margin of discretion to the Commission and focus on the procedural aspects, or whether the court is willing to go into the nitty-gritty and see how the Commission assessed the technical aspects in adopting a decision.
Thank you very much, Constantina. I wanted to make a very quick information or update for colleagues who are interested in this specific discussion. Also, pretty much the same time in November, there was a conference by Sheridan Partners hosted by Capital Forum, and you, Constantine, have been participating in a fantastically informative panel on these issues inter alia. So, colleagues who are interested in looking further and looking into these issues, I think it will be very relevant. I don't know if it's Googleable, but I managed to find it on Capital Forum webs.
It is. Thank you, Oles. Thank you, Oles. Moving away from my colleague who advertised my work, many thanks for that. I think the stature of judicial review will be a case in point. We will see a lot of interesting judgments moving forward. I'm really curious to see how far the court is willing to go. As you know, in competition law, when it comes to economic assessments, the court gives the Commission a large margin of discretion in terms of how the economics were assessed and interpreted. But when it comes to the technical issues, what will the court do? I'm asking myself.
Can I go back very quickly to the conference, Constantina?
Sure, absolutely.
Just to give a shout out to a series that we held in Tech Policy Press, where contributors at the conference penned a series of articles around the themes and the papers that were discussed. So it's worth checking out. And I should put it in the chat here. Thanks.
And I go back to the courts issue because I can't wait to discuss it a little bit more. My impression is that, yes, the court will need to delve into more technical issues, but it's probably not going to be the first time that the court will need to get into a sector and go very much into the nitty-gritty of the specificity of that sector. And so a couple of points there. First, I would be very, very pleased for the court to be challenged in this way, rather than for the court to be just dragged into a lot of, judicial trolling, as I tend to call it, which is this sort of boring exercise of having the gatekeeper appealing each and every decision that comes out just for the sake of delaying some processes and so on and so forth. Now, obviously, this is it's not the case 100% of the time, but a fair amount of the time. So I'm not just trying to undermine in any formal way access to justice. I'm just trying to say, again, we need to call things with their names. So I'm glad that those judges, they will have this intellectual exercise that is way more interesting than the majority of interventions they're called for. The second point is use experts. Nobody can be the expert on everything. The courts can use experts to sort of inform themselves and try to understand. There are many brilliant minds out there that they know exactly what's going on, and they would be probably happy to sort of share this in a totally non-captured environment. Once again, I think it's a problem of communication. The court will need to look for those people, and those people, they probably have no idea they could be helpful in such a cases, but this can change. And maybe part of this specific knowledge can become general knowledge at some point, so we can all advance as a society. Third element, but that's very much a sort of a long shot or a wild guess. I've seen the Court of Justice playing a massive role when it came to the single market. the integration, the harmonization, and so on and so forth. And they haven't been shy in the past. They have taken strong positions that then led to the four freedoms being, properly implemented. And this has created a better society, a better European society, I think. So my hope is that the judges, they won't be shy this time either, and they will sort of do their best to lead us to the full potential of the DMA being properly enforced, because this will deliver a better digital society.
Mm-hmm. And to some extent, the court does not even have an option, right, Isa? Because gatekeepers appeal pretty much everything. So they need to do it sooner rather than later.
Yeah.
Very good.
Can I ask a question, given my non-lawyer background? So the court, does that have to listen to every appeal? So because there's going to be lots of appeals about designations, right?
To the extent that the appeal is admissible, then yes.
Okay. Yeah, I can imagine there'd be lots of trolling in that sense.
Mm-hmm. And, from that perspective, we also need to consider that it's not just the gatekeepers that can appeal a decision. It's also business users, trade associations, and everybody with a legitimate interest in the decision, affected by the decision.
And then we go back to the interpretation of legitimate interest.
Yeah. And what's sufficient interest? Where does that come in, as opposed to legitimate interest? Without going too deep into it.
Sorry, what is? I didn't hear the question.
Sorry, sufficient interest versus legitimate interest.
I mean, legitimate interest is the legal term used in the treaties and the rules of the court. I think that it really depends on the type of organization that files the appeal. So, for example, if the commission adopts a decision against one of the gatekeepers, then clearly the gatekeeper has a legitimate interest in appealing the decision.
Yeah.
A trade association that represents many members needs to prove different things when it comes to the admissibility standard for the appeal to be taken by the court. There is a different legal test. So it really depends on the type of organization we're talking about that files the appeal.
Sure.
Great. Maybe at this point, we can invite both of you to maybe share with us your crystal ball gazing results for the first maybe quarter of 2026. What will be preoccupying your minds, and where do you think the main developments in the DMA we should expect? Isa.
I'm going to limit myself to 2 or 3 points, very broad, and then there plenty more, obviously. And maybe I'll ask for a second round after I see what Mark is going to hint to. The first one is I'm a bit worried about the political scenario and the wind that goes in the direction of deregulation and simplification. I think in a way or another, it can impact the DMA or the way the DMA is enforced, and it would be very detrimental. So I think as civil society, we need to sort of, even if we don't have any capacity to be present on all the different bits and pieces that are under this umbrella discussion, unfortunately, if you ask me, we need to keep an eye on what's going on there, because depending on what kind of moves will be taken in that discussion, the impact will be visible in the DMA enforcement. So this is one. The second one is I am pretty looking forward to see what is going to change in the enforcement now that the Chief Technologist Officer should be there up and running, and to see if this is going to be a sort of a game changer or not in the kind of enforcement moves that we're going to see, investigations open, the kind of decisions, and so on and so forth. If it's probably, my hope is that this is going to be a game changer for the monitoring to start with. Not only for the sort of shaping of the decisions, where obviously it's going to have its own weight and it's going to be essential, but just to equip the Commission to do a better and wider monitoring, which is admittedly very, very difficult for people with a more traditional background. The third is, so we've spoken about cloud and AI and so on and so forth. So we'll see this matched with the DMA review period. it's going to be an intense advocacy time. And as civil society, we might need to identify those ways and those narratives that can be more effective. And my effort here, I'm it's still a work in progress, but my effort here would be to try to be as inclusive as possible. So what are the things that really matter, not only for Article 19, but that really matter for the wider society, and how we can sort of multiply the message as much as possible as a strategy. There is a final point that is very, very dear and close to me, especially as an Article 19 person, which is we've touched upon very, very briefly. Constantina, you said generative AI, and then we didn't have time to elaborate. I think generative AI as a massive list of things to be dealt with, become a public interest technology, or a technology can be used in a public interest. But there is a specific aspect. I do believe that generative AI is not only a free expression issue, but is a freedom of opinion issue. And now freedom of opinion is an absolute right that everybody has. And most of the generative AI tools out there, they do interfere, or they have the potential to interfere with this inner sphere of every individual. And it's a revolution. We need to get equipped on how to deal with this. It's not about the attention economy anymore, because it's not something that is happening out there. It's something that is happening inside our critical thinking. And I see this as a step change. And I'm not seeing enough discussion about this. I don't know if it's going to be a DMA issue. Definitely not be a DMA issue, but is one of the most interesting thing and challenging things we're going to work on.
Many thanks, Isa.
100%, which gives me... Go ahead, Oles, go ahead.
No, I just wanted to ask the same question, Mark.
I haven't given it quite as much thought as Isa, or at least I don't have quite as much to say. I'd obviously second what you said. I think I'm certainly heartened by Ribera's comments, where she's reinforcing the need to constantly enforce. And it would be nice to see the DMA increasing in personnel in cases and investigations. I think specifically to a particular area, I'm looking forward to seeing the outcome of the AI overviews complaints, whether it'll be taken up as a formal investigation. And then more on a personal interest, I'm interested in the news publishing environment and the interaction between the DMA and the EMFA. We've seen very little yet on the EMFA in terms of implementation. So I'm looking forward to seeing how that materializes over the course of this year.
And I think this gives us the excellent opportunity to ask the final question we had in mind, because Oles and I could not but ask about what you think regarding recent enforcement initiatives. And I'm referring to the recent investigation into Google's SRA policy, and of course, the antitrust investigation into AI overviews. We both think that these are issues relevant to obviously the enforcement of competition law and the DMA, but also issues relevant to freedom of expression, media pluralism. You have a gatekeeper that may want to interfere with a business model that publishing companies, media companies may want to adopt. Where are the limits? So what are your views on the recent investigations? Obviously, I assume you welcome the investigations, but what do you expect in terms of the outcome of these investigations?
And maybe you can update us on some forthcoming investigations if you have this information or rumor.
I can spill the beans.
Anything else? My take is that I'm very glad this is happening. I like also the fact that it's happening not only in Europe, but it's some of these issues, they're getting attention outside of Europe as well. And the attention they're getting, it looks slightly different. Which is a good thing, because as you rightly said, now what we're dealing with is competition-based actions. But the target or the goals here, the final goal, it's something that goes beyond the core of what competition is supposed to address. And it is something that is looking also and especially at the media environment, plurality, diversity, independence in the media, which is something that we as society, we need especially in this timing. I think is an issue that goes. It's one of those sensitive issues and sectors that bring us from this is a regulatory problem to this is a democracy problem. It's one of those very evident bridges. So I am glad, as I said, that all this is gaining the attention it deserves. To a certain extent, I think it is so important to intervene in this sector and to dilute power in this sector that I don't even reason in terms of, well, this should be covered by 102 or rather by a DMA provision or rather by Article 22 of EMFA or Article 18. It doesn't really matter. Whatever the instrument to bring us there is where democracy lies. So we need to go there. And if different regulators in different parts of the world, they're going to experiment possible ways, the more, the merrier, as long as we get there as a society.
And Isa, just a quick point on enforcement here, because I really like the comment that you made. It doesn't matter which tool is used. I think it's also important to mention here that all tools can be used, because we wouldn't have a problem arising from double jeopardy. For example, the Media Freedom Act pursues a legitimate interest that is completely different from what is pursued by the DMA or competition law. So obviously, if we want to have effective enforcement, arguably, if regulators are overzealous, they really want to do something about it, they can pursue their distinct cases, which goes back to the discussion on how to achieve effective regulatory cooperation, because the tools are there, as you said.
Exactly. And we're a big fan of ambitious regulators in this case. I'm also totally aware that this is what we can say in Europe, or confidently say in Europe or in certain of the member states. In other areas of the world, this very much depends on the level of independence and accountability of the regulators, and it's a long way to go. But I absolutely see what you're saying, and in principle I agree, and I hope that in as many jurisdictions as possible, the different authorities will be equipped as soon as possible to play their part and to do that in an independent and accountable fashion. Yeah.
Definitely time to focus on enforcement. Go ahead, Oles.
Yeah, I just wanted to ask Mark the same question.
I think I actually missed the question, Alice, because my internet went down temporarily.
So we wanted to ask your reflections about the ongoing investigations and maybe those which are in the pipeline.
I don't really have much to add beyond what Isa said, to be honest. I mean, I think given the geopolitical turmoil, I really hope that there can be cooperation and coordination between the different regulatory agencies, based on what Konstantina has just said, because I think that's going to be paramount going forward. And then the question of the will and the interest on behalf of both the EU and the member states to vigorously enforce is something that we as civil society are going to have to keep on reminding and putting pressure on them.
Great, thank you so much. So we wanted to finish with inviting you quickly to provide some recommendations to students, those who will be playing this game a little bit later. Isa.
I'm going to go first, Isa. Start competition or earlier in life would be my guidance.
And I matched this with saying, I know it sounds weird, and probably will never be able to match any of those salaries, but if you are passionate in competition law or competition policy, and you want to work for civil society, this is now possible. It wasn't a few years ago, but now it is possible. So yeah, get in touch. Definitely. And also this is for, the sort of ideological or the motives driven part. When it comes to the substance, I would say multidisciplinary research is what we need now. We've mentioned here and there specific legal issues, but the majority of things at stake, they're not just purely legal, and it's a combination of different things, and skills and expertise will make a difference on how we cope with those, we deal with those concepts. So multidisciplinarity.
Maria Luisa Stasi, Mark Dempsey, Konstantina Vanya, and myself are very grateful for sharing your great ideas with all of us. Thank you.
Thank you so much.
Thank you very much.
Thank you very much, everyone.